problem is I resent you trying to blame her for what your son didn't do. No, I'm done. Because you know what? I'm done. I'm done. 14A stands adjourned.
All right, and there's to be no gum chewing. Charged with injury to the elderly, bodily injury, that's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. People ask you to leave their property, whether you think you're being evicted. It's always best to leave. Did you understand by pleading true to violation of condition number 1, the court could find it to grant the motion, find you guilty, and sentence you up to life in prison and up to a $10,000 fine? 2024 CR 2336, State of Texas versus Larietta Nicole Holmes. Could I have parties announced for the record for the state? Defense?
Greg Desmarais.
Are you Miss Holmes? All right, you're gonna need to speak up so the court reporter can hear. Did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Counsel, have you received all the discovery?
I have, Judge.
Have you reviewed it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Ms. Holmes, did you review the document entitled True Bill of Indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to the elderly, bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up these rights and enter into a plea?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine.
Yes.
Off the record for a moment.
Susan.
Oh, no, it's not a problem. This system is new and it's taking us a while, but we're going to be just fine. We're back on the record. Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Holmes, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, no.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
I'm sorry, what?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is recommending deferred adjudication. They're taking in consideration 2023 CR 8418, and there's to be restitution of $3,700.85 to John Ripley. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 150 hours community service restitution, no contact with John Ripley or Feather Point Road, San Antonio, Texas, 78233. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plea?
No contest.
State, any evidence?
No objection, Your Honor.
And state, have you conferred or spoken to the complainant?
Yes.
All right, thank you. You may be excused. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you
Yes.
understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client has obviously, since this case occurred back in July of 22, she's obviously stayed out of trouble, Your Honor. She's been to court. She is going to school. She's becoming a business, but nevertheless.
Esthetician.
Currently she works as an esthetician, which is my understanding is skincare. And that's what she does for a living, but she's also going back to school to get her degree in business administration. She has 2 children, a 15-year-old, a 17-year-old that she takes care of. And this is a difficult case, obviously, for her judge. This is a true no contest plea, and this is what she believes is in her best interest. She wants to get off probation as soon as possible, do everything she can, Your Honor. So we just ask you to grant this and get closure on this.
All right, so Ms. Holmes, you understand when people ask you to leave their property, whether you think you're being evicted legally or not, it's always best to leave and then just handle things civilly. So if this were a case where you didn't think you were being evicted properly, all you had to do was, you know what? I'm going to file a civil case. And it appears that it is not a civil case that would be filed in district court based upon what the amount is. So you would just go to one of the JP courts and you just file it. And there are plenty of people who file that every day. And that's how you solve that, as opposed to coming here. Now you have all of these extra fees and you have this. You understand?
Yes, ma'am.
So, of course, I always have to ask this question. The piercings underneath the lip, were those painful?
No, ma'am. I
Okay.
didn't get them at the same time either. I got them over a period of time.
So what order did you get them? What was the first one?
I had got this one, I was like 16,
Mhm.
and I got this one, I was like 19, and then I just got this one, and it just compliments when I smile.
Oh, okay. I'm always wondering. And the tattoos, what are the symbols for those?
It's really not too much of the symbols, butterflies, music symbol. I play the piano,
Oh, wow.
Bible verses. I grew up in the church.
See, I always wanted to play the piano. And I was going to take it as an elective in college because everybody's like, it's an easy elective. Okay, I'm in a class that's supposed to be for beginners. Everybody in there had a piano at their home and had been playing forever. They were truly taking it as, yes. I couldn't even answer because our professor would say, in order to answer the roll call, you had to play the note he wanted you to play. I'm like, yeah, I'm out of here.
Drop that class.
I dropped it, but I dropped it before they were going to give me a W.
There you go.
I saw the writing on the wall before the end of the week. I was like, no.
Judge, as you know, YouTube that want to learn the piano, YouTube will teach you immediately.
All right, we're going to see. Well, don't put professors out of business. All right, so you're currently employed. Okay, so this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. Take in consideration 2023 CR 8418. And state, do you have that? There's going to be regular reporting by Zoom. Thank you. On the person.
Thank you.
There's going to be regular random UAs. I always have to tell people who are new to probation, when you're on probation, you're not allowed to drink alcohol at all, even at your own home. You're not allowed to do marijuana even at your own home, because what that's going to result in is that going to result in a positive UA. And people think these are my rules. These are the rules that the legislatures have put in place. So if you're UA today, is everything going to be fine? All right, what's going to be in your system? All right, so we're going to do random UAs and we're going to test for levels. So those levels need to start going down. You understand? And do not, if they file a motion to revoke because your levels are increasing, do not come back to the court saying you were around people who were smoking, because you have children. You shouldn't be around people who are smoking because it gets in your clothes and children end up smelling like marijuana. Their clothes smell like marijuana. And then children who are at school tend to tease them. And we don't want that. There is to be 150 hours of community service restitution.
May I speak to that, Judge?
Yes.
Is it possible if she can show semester grades going towards her business administration degree, that can satisfy some of that community service?
I was just about to say.
Thank you, Judge.
Thank you.
ESPN.
The community service hours. Yeah, we're here. The community service hours will be waived once she provides proof of her BA. And honestly, you should be able to finish that, hopefully, before your community supervision has expired. But if you show the court that you're actually taking classes, and when I say take classes, your attorney know I will mean this, not just one class a semester. You understand? And I understand that you work. I understand that you have children. So for you, it's going to have to be at least 4 hours a semester. And that's not full time. For this court, at least 8 hours is full time. But because of everything that you have going on in your life, probation, she needs to do at least 4 hours per semester. There's to be anger management. There's to be no contact with John Ripley or the address on Feather Point Road. And there's to be the restitution amount of $3,755.85 to John Ripley. And there's to be field visits 1 time per month for 2 months. Probation, is there anything else? Thank you. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors.
And Judge, was the fine probated? Is that something I need to address?
There was no fine asked for. You're welcome. Probation, anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Off the record, in this court, to be successful in probation, communication is key. If you have an issue, let your probation officer know about it. If you feel as though your probation officer isn't addressing it, you can always come back to the court and we'll take it up. All right, do you have any questions? All right, good luck to you.
Thank you, Judge. May I be excused?
Yes, once she talks to probation.
Reed.
Good afternoon, Your Honor. Reed Cook for the people.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Reed. Good afternoon, Your Honor. Christina Saxon for Mr. Christian Reed on the matter ending in 0422. So, Your Honor, we are both.
Only have one file.
There is only one file. Yeah. Yeah. I need it back up.
Pressing me.
There is, oh, that one's blank. There is 2 attorneys because the PD filed a motion to withdraw due to a conflict that was found just in the last couple of days. Yeah.
You write this? Okay. And I don't think I granted it because it's someone going to, I guess, address, because I have bond violations.
There is a community corrections report. I was not able to reach Mr. P the last couple of days. I know Miss Sack, because the conflict was approved yesterday, and Mac identified Miss Saxon to step in, but it wasn't. The PD is still the attorney of record technically, but Miss Saxon informed me that Mr. Reed changed his number since we last spoke with them. So I have not spoken with him. But it seems like she didn't know that was pending.
I did not know. May I see?
Well, how come you haven't been contacting community correction?
My phone had broke.
Because they've been sending alerts and sirens, Chief.
Yeah, and I was calling off my mom's phone.
On what?
Mom's phone.
On your phone?
My mom's phone.
You can talk to anybody?
No, nobody ever answered the phone.
Well, that can't be right.
He indicates they did leave voicemail. Could we ask for a moment? And
I think we got her, because if that's what he's going to tell me, I think we might have a problem. So I'll pass it, and can we get a copy of this? Yeah, I'll pass it. You can see them. Versus Kristen Reed.
Afternoon again, Your Honor. Raymond Cook to the people.
good afternoon again. Tina Saxon for Christian Cook. I'm sorry, Christian Reed.
Okay. What are we doing?
Okay. Your Honor, to address this bond violation, my client's phone broke. He called his mother, who is here, said he was calling a community correction from her phone. Her phone died, and been trying to charge it up to go to her phone provider website to pull up the bill so I can show you proof that on what day and time that they made the attempts to call. He has shown up for every court appearance. Unfortunately, you know.
I get it, but I don't have any violations because I've not contacted community corrections.
Right, he's been complying with the GPS, but they're saying he hasn't contacted since May 26th. And when he called, but unfortunately I can't prove to you because his phone has been broken, which is why PD's office couldn't reach him. And he was calling from mom's phone. That's what I'm trying to get for you. I don't have an iPhone, so I can't charge up her phone to show that. But I personally have left messages with community corrections before, and they don't always respond right away. He's very clear now. I've given him the directive that every time he calls to do a screen print so that we constantly have proof of his outgoing calls.
Charge?
No, I said I do not have an iPhone, so I don't.
No, is it tethered charge?
Yeah.
Yes. Because it hasn't been going off, so it has been charged. And they're just saying he hasn't called.
No, they're saying they've been sending alerts to the device and he hasn't called.
To call, the way I read it, says sent the alert saying call agent, not that he was in violation. It's just that his phone was broken so they couldn't reach him. So for the check-in, they use that as a method of reaching out. So it's not that
How come he didn't go down to community corrections?
he called multiple times.
No, I mean,
40.
okay, I'm not getting through to anybody.
No, I understand what you're saying.
Why didn't he go there?
The directive from the GPS was to call in. So he tried calling.
Okay, hold on. You're telling me, tell him to call in. He can't get through to anybody.
And they're not returning his calls.
And so when are you saying he called on mom's phone?
And that's what I'm trying to get for you. But
When did that happen?
The moment that it went off.
In May?
each time he
Every
said,
time. Anytime to make a noise.
but because I know you require proof, that's why I was trying to get the phone statements to show you, because the call log her call log is only going back to Sunday. So we're having to resort to the phone bill in order to try to get the exact date and time that he called.
Phone log only goes back to Sunday?
Actually, I'm looking because there's so much activity. You have to change the setting on your phone in order to keep calls beyond 7 days, 14 days. And I've run into this many times. And my experience in IT, I know that is true, that you literally have to change the setting to hold more than 7 or 14 days.
So when's the last time he called?
I can't give you the exact date and time unless I can get to the phone bill. And we need to charge the phone.
Well, how long is it going to take to get a phone bill?
Your Honor, I was just in here asking.
Online and get a phone bill.
Her phone is dead. And I even came in
Oh, okay.
asked.
Well, that's okay. Somebody's got an iPhone charger around here.
Will the prosecution?
None of this is making any sense to me.
I asked anybody, I don't have an iPhone and a charger that would fit. So I asked if anybody had an iPhone charger.
Yeah.
And she even tried calling Verizon and got into that loop with trying to get a human.
I see her on her phone right now looking through it, so I'm not sure if charging is the issue.
We've been out asking for a charger, but no, I watched the phone die, and I came in to get my charger.
Right now, then.
She must have a charger now.
Sure. Charge.
Ms. Reed.
Oh,
Are you on a charger now that has started your phone? Thank you.
what the fuck is
I will say, Your Honor, as you know from your experience, if he was ducking and dodging, he wouldn't show up for a court appearance. And the court would have said that he's complying.
I'm just trying to figure out, did he follow the instruction?
He said he did, but
He's going to be able to get online and get me a copy of the bill. That's going to show that.
That's what we were in the back doing. And because I know you have these other cases, unless you want to pass, give us time to get back on there. Trust that I will have it for you for end of business.
Well, he's going nowhere unless I have proof that he's called.
Okay.
So I think we're going to do it this way. Mr. Allen, you can take him back. I'm going to remand him back. You get me a phone bill that shows the calls, then I'll release it. If not, then I'm going to set his bond and he's going to sit.
Understood.
I'll pass it. All right, I'm going to stand in recess. You like how Mr. Cook did that? Well, I see what she's looking at. I don't think charging. No, he just said it, all right, gotta go. Court does call the case, People State of Michigan versus Christian.
Good afternoon again, Your Honor. Raymond Chopin.
Good afternoon, again, Your Honor. Christina Saxon for Mr. Reed.
On this matter, I hadn't gotten to, there's a request to adjourn preliminary examination, and I may concede to that. However, there's a bond violation report. The record should reflect that that the defendant has not contacted community corrections. It's been regarding his GPS and the like. He in court that he made calls to community corrections. There were some issues to going through the phone and what that was going to show and reveal. But in any event, the court did call community corrections. They have he's instructed to call the agent, which goes through to the computer as well as to the phone. There is no indication of any calls and or messages from the defendant at all.
Your Honor, as stated at the bench when you were kind enough to give us a bench conference, the phone number to the agent was on paper and misplaced. However, he received the number to community corrections by text. But as stated earlier, his phone was broken. So when his GPS tether bellowed out a phone number, he didn't have pen available. He and his mother, because his phone was broken, Googled Washtenaw County and in an attempt to get to community corrections. I looked at her phone bill, which shows each call. I do see where multiple calls were made to what turned out to be the public defender's office. Unfortunately, a message was left, but they did not return the call saying you have the wrong number. This is who you should call. Furthermore, Your Honor, I would ask, in the face of this potential violation, that because I was just appointed at 2:30 yesterday and just noted bond violation, that you would set this for show cause so that I could get the proper evidence to show that at least attempts were made, albeit to the wrong phone number. He has been compliant every other way. He does have a job. He works at Taco Bell. And again, to my knowledge, this is a matter of a phone call that should have been made, but he now has the number and to lock it in, tattoo, whatever he has to do to not misplace this number again, if the court's not inclined to give us a show cause hearing. As stated in MCR 3.606.
Given that you were just appointed, I will adjourn the preliminary examination to my next date, which is August 18th, 2026, 9 a.m. That is before me. As to the defendant's bond, he has not complied with his condition of bond. Certainly, you may raise by written motion, but I'm satisfied that the defendant had not called community corrections, had not kept in contact with community corrections, despite their attempts to try to contact him. I'm frankly having a hard time believing his story regarding the phone. Certainly could have been that there were calls made. There are no records of any calls made to community corrections, leaving a message to them. As I further had indicated previously, he could have at any given point in time, should it's been a problem, he could have gone down to community corrections and straightened the issue out. None of that did the defendant do. So certainly you may raise and bring whatever evidence before the court that you can find, counsel, that may show or have the court draw a different conclusion on it. But at this point, what I'm going to do is the defendant's bond is hereby ordered revoked, defendant's remanded.
Your Honor, I'm going to ask that you allow me to withdraw from this matter then, because as stated on previous case, I will be out of the country on the 18th. And so as to not delay his opportunity, and being that I was just appointed.
certainly you could file a you did indicate that to me, and I don't want to put it out any further than where I have to put it out to.
Right, I
So
don't,
I'm giving the quickest date possible. If you contact the MAC office, send in a written motion, I will order your withdrawal and new counsel.
okay,
Does that make sense?
it does.
That way. All right.
Thank you.
You probably fuck. Oh, what's it up? Oh, yeah.
You love me, bro. That's because we screenshotted the thing and I screenshotted the wrong part of the number. That's why I didn't get.
Ma'am.
Had to Google it. I'm sorry, we didn't know we could come up here and talk to nobody. We didn't know about that because we had a court date and we came to court.
Ma'am.
We didn't figure out that it was a problem. We didn't know it was
If
a
you
problem.
want to listen to me, want to just talk, because I don't have to listen.
I just asked her that so I can explain to you further because she's not explaining it.
Well, that's not true. Counsel has tried to explain it. She's explained it. I looked at it myself. Counsel, that when you're talking about counsel not explaining something to me, you are wrong. This attorney came before me and she's been advocating so that your son did not get locked up. And she has stated all of those things while we were on the phone, because I don't really want to lock your son up either. When we're on the phone talking to community corrections, she's on the phone talking to community corrections. She then came before the court at a bench conference so that she could explain and advocate for your son regarding his release. And then she did it. The problem is community corrections doesn't have a record of it. That's not her fault. So don't sit up there and try to blame her saying she's not doing her job or she's not explaining something to me. She absolutely is explaining something to me. And quite frankly, she's a very good attorney. And the problem is I resent you trying to blame her for what your son didn't do. Bottom line. I've also given her the opportunity prior to the withdrawal so that your son's case was not delayed. She's willing to step off of the case so he can have counsel and he can get before the court quicker. I've also offered her the opportunity to get to this court any information that may change this court's mind. So I'm done, because you know what? I'm done. I'm done. 14A stands adjourned.
5 CR 011411 and 2023 CR 8904, State versus Tanya Ortega. Can I have parties announced?
Lauren Espinoza for the state.
And Jonathan Alvarado for the defense.
And are you Miss Tanya Ortega?
Yes, Your Honor.
All right, we're going to start with the motion to revoke. Did you review motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Tanya Ortega who was placed on deferred adjudication in 2023 CR 8904 for the offense of aggravated robbery on December 11, 2023 for a period of 8 years? Is that you?
Yes, Your Honor.
All right, state.
Judge.
Yes.
I believe this was heard actually, and she pled not true.
So Judge,
She did. All right.
Sorry, Judge.
So do you have witnesses?
Yes, Judge.
All right.
So judges, we are, with the court's permission, asking to change her plea of not true to true. When I was here last time on this case, Judge, I was just appointed to the MTR. She has a new number one that I was not appointed to. At the time that we were here, that was the only allegation against her. And so Judge Angelini was sitting on the bench. He agreed to appoint me to the number one and give me 10 days to prepare, but also asked that she enter a plea at that time of not true. And so that is what we did, Judge, with potentially the expectation that she could come forward today and change her plea to true, which she has the intention of doing, as well as pleading to her new case as well.
All right. So, are you asking to withdraw your plea of not true?
Yes, Your Honor.
All right, State, you may proceed.
Violated condition number 1, on or about the 8th day of August 2025 in Bexar County, Texas, the defendant Tanya S. Ortega committed the offense of theft of materials, aluminum, bronze, copper, brass, less than 20,000 in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
And State, do you waive other violations?
Yes, Your Honor. State waives the remaining violations.
Any objections to the waiver?
No objections, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to revoke revoke community supervision, enter an adjudication of guilt, sentence 5 years to do, and then run concurrent with the new theft offense.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
And defense, is this the agreement you're asking the court to follow?
Yes, Judge, we are.
Has she done anything on probation?
She has, Your Honor. She was employed working as a welder for, I believe it was not Toyota plant per se, but maybe one of their subsidiaries, Judge. I believe she had many submissions as far as drug tests. However, she did have a few missed, but she was not testing positive. She had recently gotten out of prison, and she also has some pending case in Uvalde County, Judge. She was on GPS monitor for a long time out of her probation for this court. She was making payments towards that. She was also on pretrial at Uvalde County, having to make payments towards that. She got into a position, I think, Judge, where she was financially unstable, leading to the theft charge that's before you now. Ms. Ortega has not tested positive, and I don't believe the theft was drug related, Judge, as far as like trying to make money to pay for drugs. I think it was something where she was trying to have money to pay for rent and so on. And she makes those kind of admissions in stipulations on the theft case. So this was something, Judge, where we actually considered potentially going open to Your Honor to continue to see if you consider continuing her on probation. But given everything that was going on in her cases, being also on a parole hold, this was something we came to an agreement with the state for. We are asking you to follow it.
All right. So the underlying facts of the case that she's on deferred adjudication for are not great.
Yes, Judge.
So this is what the court is going to do. The court is finding violation of condition number 1 true. The court is going to find you guilty, revoke. The court is going to sentence you to 8 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Michelle Young, no residing with minors.
When Your Honor can, I have one more request regarding this case. So she does have parole hold out of Bell County. Respecting the court's sentence, we would ask that if the court would consider running that case concurrent with this case, and I do have the cause number on that.
All right, concurrent with?
Bell County case number FR 81006.
006?
Yes, Your Honor.
All right, and what the court will say is with regards to that cause number, she will only receive credit if there was a warrant issued in this case and if she was in custody for the Bell County matter.
Okay, Judge.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you were in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, let me put this in the system, then we'll move on to the next matter. All right, next we're moving on to the 2025 CR 011411. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge, I did.
Court will find that the state is in compliance with discovery.
Thank you, Judge. I didn't sign it. Okay. Great.
All right. Then she needs to sign it.
Sorry, Judge.
No
Too
problem.
much paperwork. This is restricted.
Thank you. Did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes, Your Honor.
Do you understand that your attorney has certain rights? Namely, your attorney has the right to have the passage of 2 days upon presentation of the information and 10 days to prepare for trial?
Yes, Your Honor.
And also you have certain rights, that being that you have a right to have a grand jury review the evidence in this case and make a decision on whether or not to indict.
Yes, Your Honor.
By entering this plea bargain agreement, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information on and rights under Article 26.03 and 1.051. Did you review the felony information with your attorney? Did you understand it?
Yes, Your Honor.
And we're proceeding on the information as presented, counsel?
Yes, Judge.
And you're waiving the reading of the information?
We are, Your Honor.
All right. And state you're proceeding on the information as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with the offense of theft of material of copper from Home Depot as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Miss, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Do you understand if you're not a U.S. citizen, by entering into this plea, you can be deported, not allowed re-entry into the United States, and denied naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed under 1244 to 41 days in the Bexar County Jail. There's a $1,000 fine. This will run concurrent with 2023 CR 8904. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. States Exhibit 1 in all attachments.
No objections.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
As we ask, to follow the plea bargain, Judge.
All right, this is what the court will do. The court will find you guilty, sentence you to 41 days in the Bexar County Jail under 1244, give you credit for any time served. There's a $1,000 fine. Time and money will run concurrently. This will run concurrent with 2023 CR 8904 with a case number in Bale County FR 81006. There's to be no contact with Home Depot and no contact with Lydia Angel Hernandez. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we're going to go off the record. Good luck to you. You're going to have to
Thank
make
you.
better life decisions. All right.
Yes, ma'am.
All right. Good
Thank
luck. Clean. 2022 CR 10959, State of Texas versus Santos Rodriguez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Chris Griffith for Mr. Rodriguez.
Are you Mr. Rodriguez?
Yes, ma'am.
All right. You entered a plea of guilty, and we're here. The court requested that a TAP evaluation be done and also a PSI report. Have both parties reviewed the PSI report, state?
Yes, Judge.
Defense?
Yes, ma'am.
Any objections?
No, ma'am.
No.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the state jail facility, and the state is opposing your application. State, do you have any witnesses?
No, Judge.
All right, defense, any witnesses?
Just allocution, Judge.
All right, defense, you may proceed.
Your Honor, with this offense, Mr. Rodriguez made contact with police because he was riding a bicycle without lights in the evening. He consented to a search. Checkbooks were found in his backpack. Further investigation by SAPD revealed that a completely separate individual, a Dave Thomas, who I'm assuming is not associated with Wendy's, had actually taken those checks to the HEB parking lot that Mr. Rodriguez had found the checkbook in, and that he had cashed those checks. Fingerprints verified that, video verified that a Dave Thomas was cashing these checks. It was not Mr. Rodriguez. At the time, Mr. Rodriguez was homeless. He was having substance abuse issues. Since that time, Judge, he's wanting to make changes in his life, because the largest change between then and now is that his girlfriend ex-girlfriend currently, is pregnant with his first child. He wants to be there for his child. He wants to make a change in his life. He's spoken with his mother. He's able to live at his mother's home. His mother is elderly. His brother passed away in March. His sister is in the military and has four more years on her contract at the base she's at in Kansas. He has spoken with, Steve and Sons. I keep wanting to say Dave and Sons.
Yes,
Steve and Sons doors.
Excuse me. It can't be two people speaking at the same time. If you want to talk, you have to be placed under oath. Do you understand?
Yes, ma'am.
All right, defense.
There's also another company off of 34th Street that his mother has spoken to that he could get employment with them as well. And lastly, Your Honor, I would just point out that the PSI revealed that Mr. Thomas, the individual who actually cashed these checks and was involved with that, he received 3 months, 10 days in state jail. Just if Your Honor was interested in comparative sentencing.
All right, anything from the state?
Judge, just that he has had several cases where he has been given the opportunity. Back in 2017, he was given the opportunity for 2 years to defer on a possession less than a gram. He got revoked on that, was sentenced to a year in the state jail facility. In 2018, he was sentenced to 8 months in the state jail facility.
Our reporter says she can't hear you.
Can you step up to the mic?
Sorry about that. He's been given opportunities previously to be on deferred adjudication, and he was not able to successfully complete that deferred adjudication. The state is asking for 12 months in state jail.
Okay. All right. Is there anything you wish to say, Mr. Rodriguez?
Yes.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand.
I actually did my sentence he said 2017. I was still in jail in 2017. I didn't get out till 2018.
All right, so I want you to focus on why I shouldn't just send you to the state jail facility. That's what I want to focus on. The state wants you to go to the state jail facility because they're saying you're not a good candidate for probation. So my question for you is, why shouldn't I just send you to the state jail facility?
I've been clean since I've been in here, and I was clean 4 months prior. I've been trying to better my life. I actually went into many changes. My brother just recently passed away, and I gotta be there for my mom.
Why do you just know that you need to be there for your mom now that, excuse me,
I'm sorry.
why are you just realizing you need to be there for your mom when you were in the free world and you were not doing anything to be there for your mom?
Because I'm having a child now, and I did my first. I didn't really know what she was going through, what she did. She did a lot for me, and I didn't really pay attention.
So I'm going to give you a choice. You can either go to the state jail facility for a year, or you can go into inpatient treatment. And that's what's being recommended for you. So which do you prefer? Do you want to do the state jail facility time of 1 year, or do you want to have probation and go into inpatient treatment?
I'll take the inpatient treatment, ma'am.
Okay. All right, this is what the court will do. The court will sentence you to 1 year in the state jail facility, suspended and probated for 2 years. There's a $500 fine that will be probated. 200 hours of community service restitution. I'm going to want parenting classes with Triple P. Once he completes parenting classes, then the community service hours will be deemed to be satisfied. Regular reporting by Zoom or in person. The UA hotline upon release. I'm going to want SATF referral. Well, he's already approved for SATF, so we're going to do SATF. And we can do a referral to felony drug court as well. He's to remain in custody until transfer to SATF or felony drug court. Upon release, I'm going to want field visits one time per month, and probation if he's accepted into felony drug court, or of course, whatever felony drug court conditions have, then that's what they'll have. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Probation, is there anything that he needs? Anything else? Is there anything else you need from the court in order to be successful?
Oh, man.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You have a child that's coming into this world. You have elderly parents. You're going to have to start making better decisions. If you are not going to be a parent that this child can be proud of or look up to and want to imitate, then do not bother being in that child's life. Do you understand?
Yes, ma'am.
All right.
Actually, with the money that we're gonna be getting from my brother's accidental death, I just actually used my cut for open a nonprofit organization in his memory to help people.
All right. Good for you. Thank you very much.